The impact of losses in the oil and gas industry can affect millions of people. It is one reason governments are so heavily involved and why litigation can be so contentious. For an update on energy litigation, we welcome back Tracy Alan Saxe from the law firm of Saxe Doernberger Vita. Here is what he had to say.
I would say the most exciting issue these days with coverage claims for the energy industry is the recent decision out of the BP oil spill, which we've actually written quite a bit about, and the implications for additional insureds in the industry. And there's actually been a lot of issues that have arisen in commercial property and builders risk policies as well. I would say the most common source of conflict between insurers and policyholders these days on the builders risk side with the energy industry is going to be typically things that revolve around the faulty workmanship exclusion. And it's worth always noting that almost all the policies days on the builder's risk are all risk policy, which is an expansive grant of coverage. We're often seeing denials based on faulty workmanship exclusions, and they often don't incorporate the concept in that denial that there is an ensuing loss provision that is an exception to the faulty workmanship exclusion, and it provides a tremendous amount of coverage because it's a matter of describing what is the faulty workmanship and what is the defect as opposed to what's the ensuing loss. If the faulty work is actually a very narrow scope of the issue and everything else ensues from it, everything that ensues should be covered under the policy. I would say there's really two aspects of what a risk manager should and could do. One is on the acquisition side when you're buying the policy. The ensuing loss issue is a much bigger and more difficult issue under what I would call the American form of the faulty workmanship exclusion. However, the energy industry, it's not too difficult, and you should ask your broker and talk to your insurer, but it's not too difficult to get what are called the London Engineering Group, or LEG forms, and there's a LEG 1, 2, and 3, and generally speaking, the higher the number on the LEG form, the better it is for policyholders. I'll give an example. The LEG 2 form, the way it describes the same situation is it only excludes from coverage that work, the cost of what work could have been done right before the loss occurred. Everything else other than that work that would have prevented the loss is absolutely covered. LEG 3 is even better. Everything is covered except improvement and redesign costs that might be associated with redoing something on a better level. So that's one solution. And the second solution for a risk manager is when the claim arises, you need to organize your team, make sure you've got your forensic people, your coverage lawyer, and you've just figured out what happened before you tell the story. You've reviewed the policy, you understand the coverage, the exclusions, the sublimits, the deductibles, and then describe the policy, the loss in such a way that matches the language of the policy so that you don't say things inadvertently that'll cause you to fall into exclusions that really should not apply. And corollary to that is avoid all the finger pointing right at the outset once the loss occurred with emails running back and forth between the different contractors accusing them of this loss and that cause. What's going to happen is your insurer in the coverage litigation at some point is going to cherry pick those emails that they like and ignore the other ones and use them against you.
For more of our coverage of the 2015 IRMI Energy Risk and Insurance Conference, visit the RIN TV On Demand Library.